Yes.
Yes, my lords, if I can now move on to a number of points that were made in relation to the learned judge's approach and weight that she attached to various considerations. And before dealing with that, I can just point out that the principles of interpretation, the pure principles of interpretation, as opposed to those which apply to anything which may apply to leases, was not in dispute below. The learned judge was referred to the handy little summary in Arnold and Britain given by Lord Newburger. If one looks at her judgment, one can see that she went through these considerations one after another. Indeed, if anything, sometimes it's said that the process of interpretation is a little bit more intuitive than that, rather than following a menu of considerations. But she cannot be faulted for following the menu of considerations in the way that she did. It's impeccable in that sense. Various points have been made in relation to that process, and the first of those is obviously the contemplation point, and if I can describe it as the Radford and de Furberville basket of issues. But it's worth just reminding ourselves exactly what it was that the learned judge looked at or took into account when she was considering what was in the contemplation of the parties at the date of the lease. And if you turn to the core bundle at page 78, paragraph 56, one can see the way she put it. It was based on the position that was adopted by counsel below at paragraph 56. And if you can read that, you can see the concession that was made. So it wasn't just the Radford and de Furberville particular risk, and obviously in my friend's skeleton argument one can see that, and this morning certain points were made about the difference between the disputes in the Radford and de Furberville litigation. There was more than one claim from the law report. It wasn't just that one case. There were other aspects to that litigation between at the time.
More fundamentally, it's a site with obvious development potential. We're talking about a site in Holland Park, let's face it.
Yeah, I was going to come to that. It's blindingly obvious. This is one of the reasons we have this dispute, this issue here, is that it's an extraordinarily valuable piece of real estate next door, undeveloped real estate, over which there is a restricted covenant with obvious obvious potential for disputes. In addition to that, there has been litigation in the past, and it was conceded below that the risk that there was the possibility of a dispute over it. Now, the appellant seeks to get around that by saying, well, actually, too much weight was placed on it, on that consideration. But in my submission, if weight is placed on it, the consideration placed on it, it's either relevant or it's not relevant. And here it's relevant to telling us what was in the contemplation of the parties, the risk of litigation, and therefore the risk that the landlord, the freeholder, would incur those costs. As far as the references elsewhere in the relevant covenant are concerned, the context of the covenant, I can start with, I can deal with 4.4. Quite a lot of the time we have concentrated on 4.4G2 and 4.4L, but it is worth looking at the obligations as a whole. The obligations of the lessor are at page 790, the beginning of the obligations that were previously referred to in recital 6.
Where are you?
So this is at page 790.
Sorry, what is 790?
Sorry, this is 790 of the supplemental bundle. So, as luck would have it, we've ended up putting the only relevant piece of evidence, I think, in supplemental bundle as opposed to the core bundle.
Are you in the lease?
Sorry? I'm in the lease, yes.
Oh, that's in tab 3.
It's tab 3. Page 10. Starts at page 10.
Oh yes, I'm sorry, I was looking. I have a copy. Extracting documents. Yes, I'm terribly sorry. So let we look at page 18. One can see, the page. The lessor with intent to bind herself and her successors entitled.
Yeah.
For the time being entitled. And those are the obligations. And then 4, subject to and conditional upon the lessee performing and observing the regulations, and so on. And one of the points that is made is that it's suggested that there's a certain tension between the obligations and what is provided for at for F2 and 4.4G2 and 4.4L, and because there is a discretion that is built in to G2 and L. In my submission, there's nothing in that. It's perfectly possible for one to be under an obligation that is constrained by an obligation, a power to do something. There's no tension there. And this is a good example of that. But it doesn't detract from the fact that the landlord is obliged to do these various things. And of course, that was a material consideration taken into account by the learned judge in relation to clause 4. I'll come back to the distinction between that and recital 6 or definition 6 later on in my submissions. But it is accepted that there are various specific references to litigation, in particular at clause 2.6, which specific on page 7.8, page
14.
yes, page 14, which specifically refers to solicitors, counsels and surveyors' costs. There's a distinction there. And 2.9 over the page. To pay to the lessor all reasonable and proper costs, charges and expenses, including solicitors, counsels and surveyors' costs at any time incurred by the lessor in or contemplation of proceedings under section 146 of the LPA, as sometimes known as a 69 Marina clause, which is the way that it was referred to by the learned judge in her decision. So there are specific references to litigation. One point that may have not been stressed is that there's also a provision at page 27 at clause 8 Roman numeral 1, notwithstanding anything herein contained, the lessor or other the owner or owners of adjoining or adjacent premises shall have power without obtaining any consent from or making any compensation to the lessee to deal as they may think fit with any of the land or premises adjoining or contiguous to the demised premises, and to erect or suffer to be erected such adjoining or contiguous land and premises and buildings, etc. It's plain that the draftsman had in mind a particular formula for dealing with things that happened on adjoining contiguous land. And again, in my submission, that has a similar, that operates in a similar way to the specific references to potential litigation costs. As far as the point that is made, or the suggestion is made, that one has to bear in mind that this was either a lessee-owned freehold company, or at the very least at the date of the lease, it was contemplated, the 1989 lease, that it was contemplated that the freehold would be assigned to a freehold company, to a lessee-owned freehold company. In my submission, that should not be taken to be a relevant. That should not be a relevant factual situation, circumstance, because for the following reasons. Firstly, the date of the 1989 lease, it was not a lessee-owned company. There was the potential for it to be a lessee, for the lessees to acquire the freehold through a vehicle, but that was not the situation at that date, and it's rather odd one of the consequences may well be of what is being submitted that one would have a different meaning to the lease at its inception, at the date of acquisition of the leasehold by the lessee, freehold by the lessee-owned company, and then what happens during the remainder of the term in the event that, for some reason or another, again the freehold interest changes hands, because there's nothing in the lease to suggest that there's any reason why the lessee-owned company cannot assign the freehold to another, or indeed there couldn't be a collective enfranchisement, for example, where some lessees would acquire the freehold from this company. There's all kinds of possibilities. What happens if the freehold company goes into liquidation and we have the freehold going bona vacantia to the Crown, and the Crown then disposing of the freehold. In all of those circumstances, one wouldn't have a lessee-owned company throughout the remainder of the term on the hook of covenants, and therefore, in my submission, it's artificial to suggest that that is a material consideration. And in particular, as already averted to, there is no general principle that one should recover 100% of costs of any kind in connection with a freehold. That is a commercial bargain that is reached at the date of the lease. When it comes to, there was an additional point that was raised. The point was made that the respondents supported the litigation with Ms Hicks, and indeed paid service charges, paid as service charges contributions towards the costs of the first claim. That is true. This was characterised below as being the question as to whether at any point the respondents could get off the train once the train had started. Were they contractually entitled to get off the train at any point? There are all kinds of explanations as to why liability for the first contributions to the first claim might not be disputed. The basic position was that the respondents have never contested liability to pay service charges prior to the 9th of July 2014, when they wrote to the freeholder and its representatives to say that they were not intending to contribute anything further towards the cost of the litigation through the service charge. I have almost, there's no particular reason for us to explain why we took that, why the respondents
Well, it's
took
irrelevant,
that view,
isn't
but
it?
I adverted to it
It's
in my...
irrelevant.
It's irrelevant. The fact that we may well have not contested liability for service charges before 9th of July 2014 is not in any sense an admission of liability to pay service charges under the terms of the lease. I've dealt with Radford and de Furberville and the concession that was made. And I now turn to another point, which is, it's really the third issue that is raised by the appellant. And that is the suggestion that it was wrong for the learned judge to have given consideration to the quantum of costs, the very substantial quantum of costs. She dealt with this at paragraph 57 of her decision, and again I'd invite you to look at that. That is at page 78. She dealt with it under the consideration of commercial common sense. dealt with the extraordinary level of costs. And what she said there was the existence of such obligations would not make commercial common sense because they would make the lease and freehold unmarketable. It is unlikely the original parties intended this, and if they did, they would have made express provisions. But one then has to look at what she was talking about there, and that's in the preceding sentence. If those costs are part of the service charge, then so are the costs of any litigation brought against or by the owner of the garden plot or in future. Landlords and lessees would have an extraordinary commitment to potentially ruinous costs. The point here is not so much that she was looking at the quantum of costs that were actually incurred, but in a sense, the proof of the pudding is in the eating. She was looking at the potential for ruinous costs, the unlimited nature of the obligation that was suggested. And as I say, the proof of the pudding is in the eating. As it turned out, there was a very substantial exposure. But what she was actually considering was the potential, the unlimited nature of the obligation. That's the factor that she was taking into account.
Yes, well, you understandably, having been successful in the court below, say, well, we have a decision in our favour, and you point us to all the bits of the decision that support the conclusion.
Yes.
But at the end of the day, we have to decide what the right interpretation of the clause is. And of course, we give weight to the decision of a respected specialist tribunal. But it's perfectly possible for a respected specialist tribunal directing itself correctly in accordance with the law, nevertheless to reach the wrong conclusion.
Absolutely, I accept that. But in a sense, I'm responding to the criticism that is made, and by definition, I am inviting you to rely on that as consideration in the same way that the judge below relied on it. But there is another point about the quantum, if I can put it that way, the quantum of the sums involved. And that deals with this point that one has to take particular care with onerous and unusual obligations, and that the requirements should be particularly clearly spelt out. And what we say about that is that it's onerous, that the suggested interpretation as given by the appellants in this case are particularly onerous because of that unlimited nature, this point that was made by Judge Cooke below, potentially onerous and potentially ruinous. That is an onerous obligation, which we say liabilities should be clearly spelt, very clearly spelt out.
I wonder how much weight you can place on that, because the point that's made against you is, regrettably, this is inherent in litigation in this country. It is a fact of life that if you are unfortunate enough to be embroiled in litigation, it is an open-ended commitment unless you're in a tribunal that either employs no cost shifting or cost capping, something of that kind. But in any kind of general litigation, regrettably, you may be dragged up to the Supreme Court. You may be exposed to devastating costs.
Yes,
it's the nature of the beast.
Yes, but I accept that. One can end up in the Court of Appeal over a service charge.
Yes.
And indeed in the Supreme Court over a service charge dispute. That's accepted. But here we've got something slightly different, because that is perfectly the case. Within a lease, within a clearly identifiable dispute over something connected with a lease within the building is one thing, but it adds a completely different dimension if disputes in relation to neighbouring land are brought into that, because in truth, almost anything, any dispute with neighbouring land could be characterised between one of these headings that is being suggested within clause 4.4 G2 and 4.4 L. And we were reading in the papers this morning about the difficulties of non-scientists understanding the concept of exponential growth. But when one adds in one adds in adjoining land, one can see that the potentially onerous nature of disputes grow exponentially. It's a matter of degree, but nevertheless, it adds a completely new dimension to the risk and the potentially onerous nature of the costs, as proved in this case. But the other consideration under onerous and unusual is the unusual aspect of this. My friend reverted to it very briefly in his submissions. But in truth, and this is something that as a specialist judge of the Upper Tribunal and having been a full-time judge at the first tier tribunal before that, Judge Cooke will have been in a particular position perhaps to appreciate, and that is that the nature of these service charge costs when it comes to management of buildings was unique as far as one can tell. I have made the point before, and nobody has suggested otherwise, that council's researches over the many first-tier tribunal and LVT decisions concerning management of residential properties and the appeal decisions have not suggested that anybody has ever tried to recover costs of litigating over a restrictive covenant connected with covering neighbouring premises and tried to recover those through a service charge. It is, as far as we can tell, unique. And in addition to that, just to be, there's a double check on this, there's the RICS Residential Service Charge Management Code, which of course is not written into the lease. But the significance of the RICS code is this. The RICS code has the approval of the Secretary of State, and it has some statutory force in relation to the Landlord and Tenant Act 1987, which provides grounds for the appointment of a manager for cause. And one of those statutory grounds is that the freeholder has failed to comply with the RICS code. And it's one of, I think, 3 or 4 codes that is approved for these purposes. So it has that statutory effect. But more significantly, it has become a useful handbook used by tribunals for determining whether costs are reasonably incurred for the purposes of the Landlord and Tenant Act 1985, which is the primary statutory provision dealing with reasonableness of service charges. So it's brandished regularly in the first tier tribunal property chamber and occasionally on appeal to say that if a landlord hasn't followed the RICS code, the costs are not reasonably incurred. And nowhere in that RICS code is there any suggestion that routine management functions for residential leasehold properties include taking action against neighbouring properties in respect of restrictive covenants. It doesn't have statutory force. I'm not suggesting it has any kind of statutory force, and it's not written into the lease. but the parties will have been aware that that the ordinary practice of property management for residential leasehold properties, flats, does not normally contemplate taking action against neighbouring properties.
So what status do you say it's part of the factual context?
It's part of the. It's the
But
fact
would
that
it
it's an
have existed-
unusual. It's to show that this is an unusual and onerous obligation. I
Okay.
said onerous in one sense, but it's unusual because one just doesn't come across this kind of management function being exercised in relation to residential leasehold properties. And it's difficult to show a negative. It's difficult for us to show a negative, but at least we can say that there's no evidence to the contrary. There's no evidence of any FTT decision or LVT decision before that. There's nothing in the RICS code to suggest that this kind of cost is one that is ordinarily added to service charges.
The code is now in its 3rd edition. When was it first published?
Oh, I should know that, but I can't. I can't tell you.
Well, the
I
question
did
is, had it
say
been-
that. I
had
did
it
say
been-
that successive editions.
Had it been published by 1989?
Yes, the last one has been around for a long time. It's being revised at the moment.
No, but was it around in 1989?
I can let
If
you
it wasn't,
know.
it can't be relevant.
The first I can.
So do you accept that if it wasn't around in 1989, it can't be relevant?
Well, it's simply. No, I would say that
Nothing
it
in
is.
the code
It is
states-
relevant. It is relevant in the sense that. It's evidence that that after. I'm not saying that failure to take into account the RICS code is in any way, or the existence of the code in itself is material to the interpretation of the lease. It is evidence that this is an unusual obligation, and it was unusual in. If it was unusual after the lease, it was unusual before the lease. There's no. It had there been any evidence in the RICS, had there been any entry in the RICS code to suggest that these kind of costs would normally be some part of the management function of in relation to residential leasehold properties, one that would have been evidence to the contrary.
Okay, this
We
might be a
can find out
convenient
when the
juncture at
first
which to
edition
raise a related question, which is, am I right in understanding that although technically we are construing the 2007 lease, as a matter of practicality, it's the 1989 lease that counts, the reason being that the relevant clauses are completely unchanged and they can't have changed their meaning purely through a fluxion of time?
Well, I suspect my friend is arguing to the contrary, that one, is that right?
Its relevance is to what is the not I wasn't expecting to speak now.
No, sorry.
It's quite a far-ranging. It's a question with a far-ranging effect because of the nature of surrender and regrants. That's why I'm hesitating as to whether it's actually necessary to decide that point in this case, which is why
Well, I thought I was raising a point which was more or less common ground, because as I read the Upper Tribunal decision, this is how the Upper Tribunal approached the matter, namely, as I say, recognising, strictly speaking, it's the 2000 lease which is to be construed, but proceeding on the basis of the 1989 lease, because the provisions are the same and it's inherently unlikely that their meaning will have changed.
So the reason why I'm hesitating is only because the factual background changes. So it's not that the meanings change; it's because the factual background changes over time.
Well, indeed so, but does it change in any material way?
Well, that's the right reason why I was hesitating to answer your question, because I can't see that it does here, because Radford precedes all of them.
Yes,
The development potential of the land precedes all of them.
yes.
The the intention to set up a freehold company precedes all of them. The only point of distinction is that at the time of grant in 06 and 07, it was a freehold company. It's a lessee run freehold company, apologise.
Yes.
But I don't think that adds anything to the analysis because the intention was already always there in 1989. And it's for that reason why I was hesitating in answering your question.
All right, thank you.
The reason I hesitate as well is that I'm aware that it's certainly been found in other courts that one looks at the factual matrix at the date of the surrender and regrant as opposed to the factual matrix at the inception.
Well,
But
absolutely, which is why technically we have to look at the 2007 lease. But in circumstances where the parties in 2007, and certainly in 2006, and maybe you can differentiate what happened in 2007 because it's the effect of what was done then. But certainly in 2006, they expressly decided that they were going to adopt the same clauses as has previously been adopted. And there's nothing to suggest that they thought that merely because they were adopting them at a different date, they were thereby changing the meaning of them.
which is practically, I think, the submissions I have made elsewhere. I slightly hesitate. The logic is impeccable, but I would nevertheless not want to suggest.
All right, but the bottom line, as I understand it, is that neither party before us is urging upon us that we should not view the matters through the prism of the 1989 lease, but on the contrary, should put it out of our minds and view the matters exclusively by reference to the 2007
The
lease.
factual matrix at the date of the earlier lease must be material.
Yeah.
In that regard, I think the first edition of the code was in 1997.
Yes.
So
97. Yes, but well, in any event, that helps with the date. But I wouldn't want to get to end up going down too many rabbit holes here. What I'm saying is that the RICS code is simply showing that this kind of provision or this kind of obligation would be an unusual one.
can I understand how this breaks down? When Ms Hicks comes to lessor and says, "Please may I have your consent?" Lessor at that point decides that it needs the advice of a solicitor and considers that it is obliged to obtain that advice by virtue of the provisions of the lease. And so it incurs those costs. Do you say that right from the start that is not an expense which is within the service charge?
We say none of it is within the service charge. Nothing to do with the covenant over the adjoining land or advice taken in connection with that is a recoverable cost.
So that's the dividing point, is that you say there's a bright line division, that if it concerns the adjoining land, even though the proposals might mean that the building itself will fall down, it can't come within the the service charge.
Drawing the line is a difficult thing because there are obviously shades between that and other kinds of activity. But what we would say is that it falls on the wrong side of the line.
But I thought everyone was agreed here, including your clients, that the proposals for which consent was sought did imperil the safety of the building.
I don't think it's not fully accepted. If I can, it's not accepted. No, it's not accepted. And of course the proposals were different at different times, and so it's slightly more nuanced.
Let's assume that the proposals would imperil the safety of the building, or arguably might, or there was a fear that they might. why doesn't that fall full square within the obligations of the landlord under the relevant clauses?
Because we say that's not the function of that part of the covenant. We say that those are words of qualification rather than expanding the obligations.
Sorry, which words of qualification?
If one looks at the at 44G, G2.
And just as a preface, I know we're talking about service charge recovery, but this is part of the landlord's
Obligations.
So
Yes.
the starting
So-
point is the landlord's obligations.
Yes, so what one looks at, well, if we start earlier, I mean, it's perhaps easier to start earlier in the condition, the obligations. So one starts at 4.4. We have an obligation to maintain and keep in good and substantial repair and condition the main structure, and gas, water mains, etc., and the common parts, boundary walls, and the caretaker's flat. And then you've got B, as and when the lessor shall reasonably deem necessary, but less often once every 5 years, to paint. So you've got a painting covenant. And that's 1, 2, and 3 Roman numerals, and then C, to insure and to lay out insurance monies at C, and then D, to keep clean the windows, and E, to pay and discharge any rates, etc. And that includes, towards the end there, a reference to 44F, which is caretaker's accommodation. And then F, for the purpose of performing its covenants, to employ caretakers, porters, maintenance staff. So these are effectively internal staff. So all of these things are ordinary management obligations in connection with leases, long residential leases of flats. And then G1, the lessor's discretion to employ an agent to manage the building and discharge property fees. So there's a managing agent there. And then 2, to employ such surveyors, builders, architects, engineers, tradesmen, solicitors, accountants, or other professional persons. And what we say is that is read in the context of A to F, and that refers to tradesmen, solicitors, accountants, or professional persons in connection with the functions that we've already referred to. But the words "as may be necessary or desirable for the proper maintenance, safety, and administration of the building" limit the generality of the staff. So they're not words that expand on the categories of staff that may be employed. They limit them. Otherwise, if the words weren't there, it would just be any staff for any purposes.
Well, how do you explain the circumstances in which solicitors would be engaged?
Well, if we have here the word solicitors, so you look at the functions in A to C, A to F. You look at all of these things here, and the proper maintenance, safety, and administration of the building. Then, so you ask yourself the question: are the solicitors employed, so the costs are incurred, are the solicitors employed necessary or desirable, are they necessary or desirable, and are they for the proper maintenance, safety and administration of the building in the light of the previous covenants? But those words, as may be necessary or desirable for the proper maintenance, safety and administration of building, don't add to the previous covenants. They limit the words employ such surveyors, builders, architects or engineers. Otherwise, any engineers or any surveyors could be employed. That's their function.
But for instance, in relation to the previous covenants, the covenant to maintain and keep in good substantial repair and condition the main structure of the building, boundary walls, etc. On the face of it, that would seem to me to include taking steps to prevent for third parties from undermining them. It's not much good maintaining them if you don't stop somebody digging down underneath your foundations so the whole building falls down.
But this goes to another consideration by the learned judge below, which was to do with the proximity of the risk. In my submission, one has to also, there has to be a limit to that. It's not, one cannot say that that anything which may at some stage result in a physical risk to the boundary walls or the structure of the building can fall within that covenant. So, for example, let us say that Parliament proposed to change the planning laws to make it much easier to build Ms Hicks's development. The restriction on planning, or the Town and Country Planning Act as it's currently worded, could be said that by lobbying to change or to oppose a change.
But that really is not very proximate. Whereas
it isn't proximate.
when your neighbour is asking for your consent to do works which it might be perceived would undermine the safety of the building, instructing solicitors to advise you on that issue seems to me to fall right within the words of G2.
Well,
And insofar as you're right, and I'm not sure whether or not I accept it, but insofar as you're right that it has to have a relation back to the earlier provisions, it seems to me it comes within maintaining and keeping in good and substantial repair the main structure of the building, the common parts, the boundary walls, all of it.
In my submission, given that the context is, and this is to do with the focus of provisions. The focus of the provisions are, in my submission, to do with the management of the building, and the relationship between the landlord and the lessees. And an example of the kind of circumstances in which you would employ a solicitor in connection with something to do with the structure and exterior of the building would be, for example, if there was a requirement for consultation over major works. You wanted to replace the roof of the building, and there was a requirement to draft Section 20 notices, or indeed seek dispensation from the tribunal under Section 20ZA of the Landlord and Tenant Act of 1985. These are sort of classic management functions, and these are exactly the sort of things that one finds in the RICS code being dealt with routinely since the 1985.
So just to be clear, what your submission is that when the request comes in, the lessor is under no obligation under this lease to take steps to consider with experts whether or not the proposals might damage the building?
The answer to that is our submission. We say it falls that would fall on the wrong side of the line. It would be too proximate. Not proximate.
So this question of proximity is one that the Upper Tribunal addressed at paragraph 59,
Yes.
if I've understood correctly. So now we'll have a quick look at that.
I suppose this slightly brings in the asset hold issue. Asset hold involved cost of litigation involving an injunction over works which had already begun and in breach of the without a party wall agreement. That was held to be recoverable. We say, insofar as it's material here, it's very different. It's not proximate in the same way. It's much more proximate, that particular threat, than the rather distant threat when works haven't even started, and we're merely concerned here with the principle as to whether the landlord's covenant can be exercised to prevent a certain type of development. It's a long, long way from the actual threat to interfere with the, or actually interfere with the structure and exterior of the building or the walls or the other parts that are identified in the lease. So it's very different. But obviously,
And just so far as the last sentence is concerned, as was explained earlier, one of the categories of costs which is in dispute was objecting to the planning application.
yes. But again, we say that was that's too far. That's a planning application in respect of the adjoining land, and there's no actual immediate threat to interfere with the structure and exterior of the building.
Someone may get planning permission and never build.
Sorry?
Someone may get planning permission but never build.
Yes, and there are obviously along any development, I make the point in my skeleton argument, along the journey of development, there are all kinds of stages, and we say, we accept that this proximity argument involves a matter of fact and degree, and we say here it's too distant. Exactly where you would draw the line is probably hazardous. You don't need to do that. All you need to say is whether the court considers it is on one side of the line or the other. So there's infinite possibilities between planning or the restricted covenant and the actual digger interfering with the wall of the building or the wall falling down. So, that's so it's probably not a good idea to draw that line. But we say it's clearly on one side. That deals with the immediacy of the threat argument. If I can now come to the new ground of appeal,
It's not a new grounds of appeal, because this has always been in the grounds, but it's a new point sought to be taken on appeal, which involves an amendment to the statement of case.
Yes, I strictly speaking, permission to appeal wasn't given on it, on this point. So
Oh, was it
is
not?
a new ground of appeal.
Ah, that I hadn't picked up.
But in any event, I'm not suggesting that there was any.
I'm a little puzzled by that because it was in the original grounds. You're saying it wasn't within the scope of
No,
the
it
original
was,
grant.
what happened was the skeleton argument reserved the position, I think. You can just bear with me.
Well, yes, but sorry, I'm sorry to be very technical about this, but am I wrong in understanding that the original grant of appeal by the Upper Tribunal was unrestricted? Because sometimes courts and tribunals give permission restricted to identify grounds. Sometimes they give a general grant of permission. And I thought that what the Upper Tribunal done in this case was of the latter variety, namely a general grant of permission.
Well, what were they asked for?
Well, it was a little complicated because what happened was the Judge Cooke originally said that she wouldn't grant permission to appeal without the respondents to this appeal being given the opportunity to make representation. But the gun was jumped, permission was granted, the respondents then applied with its objections, asking for the permission to be set aside because we've been told we can make representations. And it resulted in the order that was made at page 82 of the core bundle.
Yeah, but that's refusal of the application to set aside the permission. The permission itself is at page 80.
Yes.
And it just says permission to appeal to the Court of Appeal is granted.
Yes. But the application for permission to appeal simply said that they reserved their position in relation to the additional point that is made. But it matters
Yes,
not.
but
I'm not
what
suggesting
the-
if there was any.
I'm sorry if I'm raising an unnecessary difficulty. I just want to be clear what we're deciding and what we're not deciding. So can I summarise? Because it would have been open to the Upper Tribunal to say permission is granted on the following grounds and the following grounds only. And if that happens, then the appellant has to apply to this court for additional permission to appeal. Now, that never happened in this case. And my understanding at the moment as to why that's so is that actually what happened was the Upper Tribunal granted blanket permission to appeal. And then when the appellant's notice was filed, it included this ground. Now, of course, that still leaves with the appellants needing to deal with the other points, which is the need to get permission to raise a new argument on appeal, and also to amend the statement of case. But as far as grounds of appeal are concerned, why are they not in apple pie order?
The application for permission to appeal, which is yes, page 105. That's the only reference to what's described as clause 1.6. In fact, it's not clause 1.6, but it's the matter. that's the only reference there. Now, it wasn't actually said in terms that that was a ground of appeal. What they said was that they reserved the right to argue. But I'm not taking any point on this. I was about to go on to say that I didn't suggest that any different test should be applied to whether they should have permission to appeal on this point, and whether they could argue a new point on appeal. I wasn't suggesting that. But
Well, I'm grateful to you for that because I mean, at the moment, it seems to me that the real question is whether they should have permission to raise a new argument on second appeal. Because I mean, if you look at the cases, you can find cases where permission to appeal has been granted, and yet when it comes to the substantive hearing, permission to raise the new point is denied. And the reason for that, while it may seem paradoxical at first blush, is straightforward. Namely, at the permission stage, the Court of Appeal has said, well, it's sufficiently arguable that you will get permission to raise the new point to justify the grant of permission. All that does is open the door to the argument in the Court of Appeal without prejudging the merits of it.
But in this particular case, we ended up in the position we did because the way it was framed at paragraph 50 of the application for permission to appeal, and the learned judge didn't specifically address it. She left it open.
And that brings us to the real question,
Yes.
which is whether they should have permission to raise the new
Well, what we say on that is, to deal with it briefly, we say that it's not limited to just the sing and das criteria, in the sense that there are a range of considerations that are relevant to whether a new point can be raised, and this is illustrated in the Notting Hill Finance and Shake case, which is page 241 of the authorities book. It's at tab 16. And I just invite you to look at the passages that are edged in red in the authorities. And there's a range of considerations there, including the explanation for not raising it, and whether it was raised timorously, and so on. But, and I've addressed in paragraph 47 of my skeleton argument a number of the considerations here about whether it was made, whether there being the explanation for not raising it, whether it was done at the earliest reasonable point, and so on and so forth. But ultimately, the touchstone is whether the most important consideration is whether raising a new point would require new evidence, or if the case had been would have been run in a different way below. what we say about that is that if one looks at the particular covenant that we're concerned with here, which is at one, which is at it's been described as 1.6, but I'm not sure whether clause 1 is credited.
No,
as
it's
that. It's
definition 6.
definition 6 or recital 6, but it's definition 6, I think, where it talks here about general expenditure incurred by the lessor in any accounting period. And then you have 2 limbs that have already been adverted to. And one, the stress has been placed on the first limb dealing
Well,
with
Before
obligations.
we get into the merits of the argument, I mean, you referred us to paragraph 47 of your skeleton argument, and as I see it at the moment, and correct me if I'm wrong, you don't there make any point to the effect that this would require further evidence. The key point you make is that there's a prejudice to your clients in costs because of the fact that there was no cost shifting in the proceedings below.
Yes, you have to bear in mind, obviously, this skeleton was submitted before the application was actually, strictly speaking, made. But we say there's another aspect to 47B, and it's this. If one looks at definition 6, whereas the words incurred by the lessor in any accounting period and carrying out her obligations under clause 4.4 of this lease is unqualified in the sense that it simply says incurred by the lessor in any accounting period in carrying out those obligations. The costs that in connection with the building, including without prejudice to the generality of the foregoing, are preceded by the words and any other costs and expenses reasonably and properly incurred. So to get within that second limb, one has to establish not only that they are costs and expenses in connection with the building, without prejudice to the generality of the foregoing, C, etc., but also they're reasonably and properly incurred. Now, had this point been raised at first instance, and the tribunal had found that they were costs and or costs and expenses reasonably and properly incurred, we would have been in a position to appeal that point on interpretation. It would have been open to us to have appealed it, to appeal the finding that they were reasonably and properly incurred. What we did instead was, because that wasn't a provision which was applicable to the first limb, we went under the analogous wording of section 19 of the Landlord and Tenant Act, and we appealed to the Upper Tribunal. And the consideration as to whether costs were reasonably incurred is a matter currently subject to appeal in the Upper Tribunal. Now, if the appellant pursues this on appeal here, and your lordships find that it's reasonably and properly incurred within the meaning of that covenant on the basis of evidence which may or may not be gleaned from the first tier tribunal's decision, we would only be able to challenge that by appealing to the Supreme Court. And we would be in a mess, because we would have an appeal to the Upper Tribunal on the similarly worded requirements of section 19, while there is a pending appeal to the Supreme Court.
Sorry, your appeal to the Upper Tribunal under Section 19 is an extant appeal, isn't it?
It is an extant appeal, yes.
Relating to the same subject.
Yes, it's this case. The FTT found that not only were the costs recoverable under 4G2 and L, but also that the costs were reasonably incurred under Section 19 of the 1985 Appellant Act. We appealed on both. Judge Cooke stayed the appeal on the Section 19 issues and only found on the contractual issues, contractual liability issues. So we would be in a mess if as a result of all of this, and we would have conducted the appeal process differently had it been done on that basis. And the point here is, quite apart from anything else, as I point out in my skeleton argument, we're outside the cost protection. Once we're in the Court of Appeal, we're outside the cost protection, which is given the First Tier Tribunal rules.
And the Upper Tribunal.
And the Upper Tribunal rules, although the Upper Tribunal rules jurisdiction on costs, strictly speaking, is exercising the same functions as the FTT under Rule 13 of the FTT rules. But that's technicalities. There's cost protection in the Upper Tribunal.
But is this a real problem? Because if we were to decide that in principle they could be costs and expenses reasonably and properly incurred, we could refer the question of the reasonableness and propriety of them being incurred back to the Upper Tribunal.
That may be.
And they can be determined at the same time as that issue is considered.
As I understood it, that's not what the appellant in this case was proposing. They want a finding, and it's clear in their skeleton
Well, they can want it. Doesn't mean they'll get it. The answer to your point with respect, I don't think, is where an appeal from this court lies. It's are you prejudiced if now that point is argued in not being able to?
I would accept you have the obvious power to remit that to any court. In fact, we could refer it to the High Court. To the Upper Tribunal, you could. I accept that power exists. I did it this time last year in this court.
And the strange thing about this point is that clause that even relying upon 4.4, the route through to the obligation to pay the service charge is through this definition, and this clause is pleaded in full in the appellant statement of case, and so the whole clause is was before the tribunal and is before this court, and it's strange to say that there is a difficulty in now looking at the whole clause when it is before us, and we must construe that clause as a whole. We must take into account the second limb in construing the first limb, and it's not as though it comes as a surprise to you that it's there, albeit I entirely accept you haven't been asked to meet that argument, except that it was raised, as you rightly pointed out, a long time ago now, that they might seek to argue that.
I made my submissions on that. They're there in my skeleton argument. But in any event, what we say is that it's perhaps one can see why it wasn't raised below, because if anything, it is, we would submit, even weaker than the other contractual routes to recovery. In particular, one can see the attraction of relying on a provision, on express provisions which refer to immunity and safety, which are words which are completely absent in this particular covenant by the second limb route. Broadly speaking, the submissions that we make in relation to that covenant mirror the submissions that we have made in relation to clause 44G2 and 44L, with perhaps the variations, following variations. The first is that one has regard not only to because of the way that it's worded, in effect, the words relied on in connection with the building, costs and expenses reasonably and properly incurred in connection with the building, are read firstly in the light of specific routes to recovery of charges in the first limb and 4.4, so all of the references to fire extinguishers and so on in that part, but also and specifically under the wording of definition 6, subject to A, B, C, D, E, and E over the page. And just as there were specific provisions dealing with detailed matters in 4.4, in the obligations in 4.4 of the lease, one finds at D, so this is definition 6D, the cost of disposing of articles and things of rubbish and refuse left in the common parts, and that is yet another example of specific references to recoverable costs, which are relatively minor items compared to the generality of that is alleged as a reading of that provision. And the only thing that one can say that this doesn't, that this is not subject to a restriction favouring the appellant, is that obviously this isn't an obligation to carry out any of these things, it's simply a power. So that argument doesn't exist for the new ground of appeal, but all of the rest do, and as far as I can see, and one also takes away the fact that there's any specific references to the safety and amenity which one finds in 4.4. So in a sense, those two considerations balance each other out. But in essence, we say that if anything, it's weaker than the other routes to recovery, and I made that point in skeleton argument. Unless there's anything further, those are the respondents' arguments.
No, thank you. Any reply?
My lord, yes. If I may, to start with, just deal with the question of the proximity. This was to be the subject of the argument on why the Upper Tribunal was wrong to distinguish asset hold, because that was the point, as your lordship identified in paragraph 59, of when proximity comes in, because it's the point of distinction for asset hold.
Well, I think the point is that it's a consideration regardless of asset hold, because that case illustrates that something that could happen in any scenario, which is you have someone physically doing works on a party wall, and that's just simply an illustration of it.
Yes, but one needs to look at the reasoning in asset hold as to why there was this threat, because that's the distinction that was drawn. And because in asset hold, it was that the action was taken, it's recoverable, the costs were recoverable, because the action was taken to ensure the protection afforded to the building by an award under the Party Wall Act. And that's what resonates here, because the action was taken to protect the benefit, not of the Party Wall Act, but of the restrictive covenants. So in the same way, what the threat was to the interference with the benefits to be protected. That was the reasoning in asset hold. That's at paragraph 62 in tab 11.
All right, let's have a quick look at that.
So, sorry, tab 11, page 153.
But it's a bit odd, isn't it? Because the scenario was legal costs incurred in obtaining an injunction before publication of a public party wall award.
Because you're not supposed to interfere with a party wall without first having a party wall award.
Exactly.
So, but it's to do with protecting the benefit of your rights that arise under the Act.
Well, but that's what I'm questioning. I mean, I take it that I take your point that that's what the Deputy President refers to in that particular passage. But that wouldn't have been the basis for the injunction. The basis of the injunction would have been straightforward up and down interference with property rights.
Well, it's doing something which you don't have a right to do because you haven't followed the Act. So therefore,
exactly, and therefore you're interfering with property rights.
Yes, but what you're interfering. But there's the imminency of the risk by analogy with us is that if your lordship asks me for a request, I have to respond. If I don't respond, I lose the opportunity to respond. If I respond and you don't, and your lordship doesn't like the response and say it's unreasonably withheld, and you sue me, I have to defend. I have to defend that to protect my property interests, which is the benefit of the covenant. So these steps are having the threat is the threat to the protection of my benefit unless I take acts, and that's why the acts which I'm taking, there's the proximity, because if I don't take it, I lose the benefit.
I'm sorry, I may be completely missing your point here, but the facts of the case were that works have been commenced on the land, including excavation for new foundations, and an application was made for an interim injunction to restrain that. And the basis for that injunction would have been the invasion of the property rights, because there'd been no party wall award.
Yes.
Have I misunderstood?
No, but that's the threat is to the property right, but in the same way there's a threat to the property right in our case, because the right that we have is to object to a request. If we don't respond, if we don't take advice as to what response is reasonable, we lose the protection of the benefit of the covenant, because we lose our opportunity to object. So if the threat doesn't have to be physical. I mean, just by way of I observed this, that in the Upper Tribunal, Judge Cooke says actual damage was being caused. I can't find anything in the judgment in Asset Hold that says actual damage was being caused.
Well, I think it's a reference to the fact that works have been commenced, including excavation for new foundation.
It might be an inference that's being drawn, but it's a bold statement to say, but there was actual damage. And then to draw that as a point of distinction, when it's not, I can't find in the facts. But those are my submissions. That's why what I say that there is here proximity. If further proximity were required or evidence, there is in the bundle, in the supplemental bundle, the replies to requests for further information. And within that, at page 149, page 149, there's a request 17. In connection, these are requests raised by the respondent of my client's statement of case. So the request is, please give details of the dates for the unparticularised continuous updates and consultation relied upon, so the applicants know the case that will meet at the hearing, insofar as the same may be too numerous, particularised, please give 5 examples of each. And the response begins at page 150. These matters are adequately particularised, the response will refer to, and then over the page at G, there's a reference to the digging of trial pits. So if we're looking at physical action, there is some evidence there in September 2013. In submissions, Mr. Loveday made what I would submit various propositions about the correct approach to contractual construction and looking at Phillips and Francis and the need for recovery to be clearly spelt out. Phillips and Francis predates Arnold and Britton, and as with the point with the Upper Tribunal, everything takes subject to what was said by Lord Newburger in Arnold and Britton, insofar as it's consistent, and it adds nothing, insofar as it's inconsistent, then it's not to be followed. That's relevant because Mr. Loveday referred to exercise of interpretation where there are onerous obligations. He didn't take you to the case, but it's the Gayford's case, which is a tribunal decision, Upper Tribunal decision. It was mentioned, or you were taken to the Liverpool Keys case for the proposition that clauses can be too wide. You recall that was the clause of whatsoever kind, but you need to read that in context because it's part of an exercise where the argument was, or the justification was, if the words had their meaning on their face, then it would render superfluous all the limitations that appeared afterwards. So it was an exercise of construction of the wording in the context of what followed. As to the relevance of the in the factual background of the intention to create a lessee-run freehold company, tab 13 of the bundle, the authorities bundle, is a case of Fairburn. It's an Upper Tribunal decision. It's a decision of the Deputy President. It's paragraph 41 at page 209. It's halfway down paragraph 41. Sentence beginning, I accept. And here the relevance of the intention to set up a lessee-run company, or that as an indicator of meaning, is consistent, I submit, with the provision in the lease that I took you to, which was clause 44N, which was to do with the recovery of costs for the formation and administration of the company.
Forgive me, I've lost the paragraph you're referring to.
I beg your pardon, my lord. So I was, in terms of the case, it was page 209, paragraph 41.
Thank you.
It's the sentence beginning, I accept. The point that I say resonates is the inclusion within the service charge recovery of the costs of formation and administration of that lessee-run company. It's an indicator of the intention to capture those costs.
Sorry, so taking that to its logical conclusion, every single cost that that company chooses to incur is passed on as service charge. I'm just not quite sure where it
As long as
takes
it's
you.
well, it needs to clearly belong within the wording of the clause. So it's not everything.
Yes. So
Yeah,
when
so
does
I'm not saying you start with and I made it very clear when I was making my submission on that earlier. I wasn't saying there's a presumption of recovery. These are factors that indicate. These are indicators. And I say it's consistent. The establishment of the intention to establish the company as part of the relevant background to take into consideration of the construction of the lease. That is an indicator of an intention to recover cost. Is amplified by clause 44N. I don't. The point made on the code has already been made as to it's helpfully made as to its timing. I mean, within the document itself, simply for your note at page 437 and 438, it makes that's the tab 25. The code, the current version of the code, not the code in existence at the time, makes the obvious point that it can't override the terms of the lease. So that's at page 437, second column just above the emboldened pages, application of the code. At the bottom of the page, there's a paragraph, the code cannot override the lease, but if read in conjunction with it, it will enable users to identify the best way forward in interpreting the lease terms to ensure effective management of services are provided. And then over the page 438, at the end of the first column, fundamentally the following should be considered when taking management decisions, and naturally refers to the terms of the lease. Just two final points, if I may. One, I've addressed you on the relevance, if any, and I say not, of quantum in the identification of the principle of recovery. It's not to say that quantum is at large and without control, because there's the contractual control of the necessity for incurring the costs, and then there's the statutory control of the cost must be reasonably incurred for the purpose of section 19. So that's where we say is the proper placement for an assessment or analysis of quantum. The final point, and please forgive me, is just simply to respond to what Mr. Loveday was saying by way of opening. You heard what he was saying about that. You heard his submission on the quantum of the vastness of, as he puts it, or as previous tribunals have put it, as to the costs. Well, it's been accepted repeatedly that my clients acted appropriately. It's been accepted repeatedly that my clients acted on advice. It's been accepted that they have been acting in the interests of the building. And respectfully, you can't begin or embark upon an exercise or consideration of proportionality without identifying the cost with which, or the interest with which you are to assess whether costs are disproportionate. There is no evidence before us as to what the value is of the interest or what effect it would have had on the property interests had the steps not been taken. So I respectfully say that's a jury point and doesn't inform as to the principle of the cost recovery.
But if the costs are reasonably incurred and on advice, etc., and yet they still amount to what in the context of residential leases are a huge amount, that must be a material consideration in looking at the commercial sense of rendering residential lessees liable without the ability to have any say in it for those sums.
Well, so we can't take the residential lessees in the abstract, so you have to look at specific properties. and we'll be familiar, there's a wide range of value of flats and apartments across the country. And so it must be identified with reference to the value of the flats that you are protecting. And we have no evidence as to which to draw any inference as to what that value might be, but against which to analyse or assess whether £2 million worth of cost is proportionate. It's not a point with evidence, but flats of a value exceeding £2 million are not uncommon in central London. But again, you come back to the point that the quantum of the cost is the product of the principal. You don't know what it's going to be to start with, and so you start with the principal. Our cost of protecting the boundary recoverable. If they only cost £2,000, nobody would say, well, no, they're not. So you start with the principal, then look at the product. If the costs were necessary and desirable, if the costs were reasonably incurred, then all the necessary contractual and statutory protections have been satisfied. Well, unless I can assist. Sorry. I do apologise. I've just been reminded that there is in Dr. Mackay's statement that was before the tribunal, which we notice at page 244, at paragraph 9, there is some material on value of flats.
All right. Very good. Well, thank you for your submissions, both of you, and for the assistance of those behind you. We will reserve our judgments and they will be handed down in the usual way, which is to say you will get a draft to those on the circulation list, which will be under strict embargo, and that must be strictly observed. The purpose of that exercise, as I'm sure you will appreciate, is to correct our typographical errors and other solecisms of that nature, but not to re-argue the case. In addition, we hope that once you get the draft, you will be in a position to agree a consequential order. If you can't agree, then please put brief written submissions in writing on any points of disagreement, and we will deal with them equally in writing. Thank you.
All eyes, if able.